After 11 o'clock, we're ready to get started today. Appreciate everybody coming in, and for those that are listening on the phone or on Zoom, we appreciate everybody being here. And with that being said, I'll have the secretary please call the roll.
Senator Rocky Adams. Senator Alvarado.
Present in the room.
Senator Girdler. Senator Howell.
President in my district.
All right, thank you. Senator McGarvey.
Present remotely from the district.
Thank you. Senator Parrott. Senator Schickel. Senator Smith.
Present in my office.
All right, thank you. Senator Storm. Representative Bentley.
President in the room.
Representative Fisher.
Present in my district.
All right, thank you. Representative Flannery. Representative Frazier.
Present in the room.
Representative Gooch. Representative Hatton.
Present in my district.
All right, thank you. Representative Kirk McCormick.
Present in the room.
Representative Koenig.
Here in the room.
Representative Cole Carney. Representative Lewis.
Present in the room.
Representative Lockett. Representative McPherson.
Present in the room.
Representative Meredith.
Present remotely in the district.
All right, thank you. Representative Roberts.
Present in person.
Representative Santoro. Representative Smith. Representative Stevenson.
Present in the room.
Representative Upchurch. Representative Westrom. Co-Chair Carpenter. Co-Chair Rowland.
Present remotely.
Thank you.
We have a quorum. We're ready to do business. Appreciate everybody. First item we need to discuss or have some acceptance on is approval of the September 14th minutes. Have a first and a second. All those in favor signify by saying aye. Any opposed? The minutes are approved. Our first item and our only item, which will probably require our time here today, is PIP, the PIP reform. We've talked about this many times. Anybody who's on Banking and Insurance Committee in the House or Senate knows that this is a topic that we've discussed in Kentucky for many years, and I've got many phone calls this week of people who wanted to come and have discussions as well. And so we're just going to allow the folks that are presenting today to have this time to discuss their side, and then there'll be plenty of opportunities in the upcoming meetings. We're not sure if there's going to be any legislation coming up on this session, but we know it's an important topic and something that we want to always discuss during our interim time. So with that being said, I know we have Mark Trish is here. We have a whole list of folks that are ready to discuss. So Mark, are you going to get us started here? If you want to bring your guests to the table, we can add chairs if we need to, if there's not enough room. And you know the routine, Mark. Always good to see you. We appreciate your efforts and your work.
Thank you, Mr. Chairman. And I will inform my fellow speakers up here that the microphones have a little on button there. When you see the light on, you're transmitting. When you don't, you are not. So, but do appreciate the opportunity to appear before you. I thought we might start just by way of introduction.
Great.
And then we'll get into the presentation. For the record, I'm Mark Trish. I'm Executive Director of Insurance Institute of Kentucky, and IIK is the P&C and life insurance state trade for Kentucky. We operate only in Kentucky, just deal with Kentucky insurance issues, try to inform legislators and the general public on those issues.
I'm Ron Green. I'm with Green, Chestnut, and Hughes in Lexington. It's a firm my wife and I started in 2010. I've been I'm doing seminars on no fault since the mid-'80s and have monitored it closely. It's actually been a while since I've done a lot of practice with no fault, but I keep up with it. I do want to digress just for a moment. I've got a young associate who joined us this year who was very excited to hear I was going to be here. And he said he was going to quit if I did not convey a message. Robert Jenkins says hello.
John.
Yes, sir. My name is John Bush. I'm an attorney.
Turn on your mic.
I'm sorry.
Sorry.
My name is John Bush. I'm an attorney in Louisville with the firm of Bush and Osborne. I've been a practicing attorney in the Commonwealth of Kentucky since 1978, with an emphasis on insurance defense ever since about 2000, 1999 or 2000. My practice has also encompassed insurance fraud defending or helping insurance carriers investigate questionable claims with an emphasis on PIP as well as property and casualty.
Good morning. My name is Owen Castor. I'm the Kentucky Medical Claims Manager for Progressive Insurance Company. We have 3 offices in Kentucky, in Louisville, Lexington, and Bowling Green. And I've been in the insurance industry really since I was in college, but 30 years plus at Progressive, 25 years in my role as the Kentucky Medical Claims Manager. Thank you for allowing us to be here.
Okay, thank you, Mr. Chairman. In this presentation, what we hope to do, as Chairman indicated, we're not bringing any legislative proposals at this time. But, given the fact that a lot of members are new to this committee, many new to the General Assembly, you may not have seen as much on these issues. We just thought it would be good to give some perspective on PIP, and should the chairs be willing, we would, plan on, also giving kind of part 2 of this in November, where we might focus more on some of the additionally on the problems and more specifically on fraud issues. But for now, we want to give a little bit of history of PIP nationally and in Kentucky, give a national perspective, and then talk about some of the issues with PIP and so on. And so without further ado, I'll get going here. So, the first question is, what is PIP? PIP is a no-fault medical coverage. It's included in your auto coverage. Probably many of you are aware that you have it. Sometimes there's kind of limited awareness of it. But PIP is something that must be included in your auto coverage unless it is specifically rejected. You can reject it, and it is optional for motorcycles. And what I'm talking about here is in general about PIP. There are some Kentucky specifics we don't have in here. I don't know whether other states, whether motorcycles are optional, but here in Kentucky it is. What PIP usually covers nationally is medical bills, funeral cost, perhaps with some limitation, lost wages or lost income if you're self-employed, and replacement services. It is designed to pay medical and other losses without determination of fault. So when PIP first came on, primarily back in the 70s, the idea was that if you've been involved in an accident and there was perhaps some contention as to fault, this would be a good way for you to recover your medical bills without waiting till the claim was settled in full. And so those covered by PIP generally cannot initiate a lawsuit for those medical damages until a certain threshold is met. And in talking about a couple of terms here, one thing we talk about is no-fault states versus tort states. No-fault states, sometimes referred to as PIP states. Tort states can be referred to as fault states or at-fault states. A no-fault state, essentially, if PIP has not been rejected, you don't get to file a lawsuit until there's a certain threshold met. In tort states, and as I said, referred to as at-fault or fault states, there is no limitation on filing suit. Of course, no provision for no-fault recovery either. And I mentioned PIP thresholds. There are 2 kinds of thresholds. Monetary threshold, which is a specified dollar amount. In Kentucky, that's $1,000. So you can't, once your medical bills hit $1,000, then you would be free to go ahead and institute suit if you're covered by PIP. Unless you're a PIP rejector, then you can do it from $1. And there is another type of threshold, which is a verbal threshold. You can maybe ask some of the attorneys why a verbal threshold doesn't have anything to do with verbiage or words, but I guess it's just a descriptor or a non-monetary. And that is in states that have a monetary threshold, a verbal threshold, then the presence of a serious injury as defined in statute in that state, disfigurement or death resulting from a crash would trigger the ability to do a lawsuit. When has PIP been enacted in various states around the country? These are all the PIP states here, or no-fault states. You can see the earliest was Puerto Rico in 1970, and then the last was Pennsylvania in 1990. However, you might notice that Pennsylvania enacted it in 74, repealed it in 84, and then reenacted it in 1990. And so for any state that has enacted PIP for the first time, then that has not happened since January 1st, 1976. Kentucky was actually the next to last state to enact PIP as a first-time enactor, and that it was passed, I think, in the 74 session, went into effect July 1st, 75. Florida is kind of a special case. Probably a good way to describe them as an on-again, off-again state. They passed it initially in 1972, repealed it temporarily in 2007, and then reenacted it in 2008. Some of you may have read there was recently legislation there that would have repealed PIP, actually this year, but that was vetoed by the governor. And since we're talking about repeal, these are the states that have repealed PIP, and you can see Pennsylvania's listed there even though they reenacted it. I didn't put Florida in because there are probably too many to mention for how much they've repealed it. This is a pictorial representation or graphical representation of the PIP states. The states in blue here are tort states or at-fault states. The states in the varying shades of purple are the PIP states, and the verbal threshold are in the darker purple, and the monetary threshold are in the lighter purple. You can see Kentucky is a monetary threshold state, and you will also notice that out of all the PIP states, none of the surrounding states of Kentucky are PIP states. The closest PIP states to us look like Michigan, Pennsylvania, and Florida. So we are kind of in an island of fault states. And then I mentioned before that it is possible to reject PIP. And so in other words, in Kentucky and a couple other states, there is a choice on whether you're covered by PIP or by a fault system. In Kentucky and New Jersey, it defaults to no fault or PIP, and unless the driver specifically rejects PIP and therefore opts for the tort system. In Pennsylvania, I mentioned them as one of the other PIP states, the defaults to the tort system. And in D.C., they kind of get the best of all worlds. All drivers are off the option of no fault or fault coverage. And in case of an accident, they kind of get a do-over, I guess, for lack of a better term. So with that, I'm going to turn it over to Ron and some of the others presenting here.
Thank you. First of all, I think some of you may be interested to know that while I'm an attorney and I practice civil cases on the defense side, often for insurers and represent insurers, I'm not here as a retained attorney for the Insurance Institute. I'm a member Now, a little counter disclosure, I have been reimbursed for work done on some amicus briefs with the Supreme Court, but I'm not generally an attorney for IIK. So I think that makes a little bit of a difference. What it really reflects is that I have no life, so I get interested in things like this. But one thing that I think it's important to understand is that while everybody sitting here has issues with the way no fault is now, I think it's important to understand that it was actually and I wasn't there. In 1975, I think I was a painter trying to go to night classes at Murray State, and I didn't care about any of this. But from everything I understood when I first became aware of no fault and started studying on it, this was a well-intentioned, bipartisan is not correct because there's more than just two interests. It's not really a Republican-Democrat thing. It's really various people that are involved with auto insurance and so forth got together and worked out a compromise as best they could in a number of issues, borrowing heavily, I understand it, from the Florida statute. But all that had to be modified because Kentucky has Section 54 of the Constitution that says the legislature can't eliminate tort liability. So there was this, as I understand it, there was a lot of last-minute cutting and pasting that led to some irregularities. The very first case that discussed no fault in 1976, I believe, was Fan versus McGuffey. And the threshold question is, because the language was pasted from Florida, if you read it literally, the No Fault Act abolished wrongful death claims. Well, we all know that the legislature can't do that because the Constitution says there's got to be wrongful death claims. And that was the first step where the court filled in gaps. And they may have, whether they were right or wrong about some of the other issues, it's all based on consent. And that's all subject to peculiarities of Kentucky law. But in any event, it's a trade-off between various interests. And it's a little bit like workers' comp in that sense. The idea is that we're going to do away with frivolous claims, small claims, claims that really shouldn't be in court, which generate nothing but defense costs and raise premiums. And in exchange, the injured person is going to receive these benefits without regard to fault. That's really the bottom line trade-off that was involved. And one of the fundamental problems now is there's only half of that is still in play for reasons we'll talk about. So its whole purpose has kind of shifted, and that's created some of the problems that we see. The way the legislature established the doing away with small claims was they set up thresholds. And Mark just talked about monetary and verbal. We've really got both. $1,000 of medicals. In 1975, when it comes to $1,000 of medicals, that was a lot of medicals. The first commercially available CAT scan was 1972. I don't believe Kentucky had one in 1975. That's a big generator of initial post-injury expenses that meet the threshold. We didn't have that. MRIs were not commercially available until 1977. And it was much later that one came to Louisville, and that was amidst a bunch of antitrust litigation. It was very controversial. And then there were some physical things, and some of them are very specific. A broken arm, broken bone, that sort of thing. Death was, I think everybody agreed, was a serious injury, except for the little mistake about leaving it out of the not abolished section in 060. But disfigurement was one. And the legislature intended serious disfigurement. And the Supreme Court, though, decided that it was sufficient disfigurement if you had a small scar only visible with a magnifying glass. And that basically busted the threshold until later the technology became available and more commonly used. We didn't really have, the physical therapy existed, but it wasn't used the way it is now. My memory is that the common treatment for like back problems was bed rest, and now it's the opposite, exercise and so forth. So there's been a lot of evolution. Just as an example of how much this has changed, I'm sure all of you have had a pulse oximeter on your finger that they took off and they threw away. If you haven't, you're lucky. When I was a young pup, this may have been even before I got out of law school, the fellow that hired me represented a major hospital, Kentucky hospital, and I distinctly remember this case where they were suing because this hospital only had 2 pulse oximeters that were so expensive. And they didn't have enough. They had 3 women in maternity, and they could only use 2 pulse oximeters, and they were blaming that. This is something that's now disposable. That's how much things have changed. And prices have been impacted by all that too, but of course you get treatment for it. So the thresholds have been eroded by a number of things, including court decisions. Now the coverage minimum is $10,000. So if you don't reject PIP, you get $10,000 of basic reparation benefits. Another little amusing thing about the courts is you'll find lots of opinions that refer to it as PIP. We all refer to it as PIP, personal injury protection. That's a Florida term. That's not a Kentucky term. They're basic reparation benefits in Kentucky, BRBs. But it's in the books, and it's just one of those things. If you look at the list of purposes for the original enactment, and this is the source of a lot of the confusion with the courts, everybody put their interest in there. So you've got a long list of purposes for the act that actually conflict with each other. One set of purposes, prompt payment of medical bills. One set of purposes is to do away with frivolous and small claims. Another purpose is to take the burden off the injured person to get medical bills paid without a lot of dispute. As part of that, the legislature, I'm so sorry, but it's true.
There's your time limit. Perfect. Oh, I'm sorry.
That's okay. I fully expect my phone to be confiscated. So the legislature set up a presumption that bills would be considered reasonable. And we'll talk about that in a minute about how that's gone awry. But it set up penalties for slow pay. And the penalties are basically an extra interest if it's just delayed without a reasonable foundation. You can get attorney's fees and a higher interest rate. That eliminated what we refer to in other tort contexts as extra contractual or bad faith claims. They don't apply to no fault. It's got a vexation type statute. I'm probably taking more time than I was supposed to, but so it was very effective initially. I remember as a young pup talking to older lawyers like Oscar Gerald's, guys that did almost nothing but auto, and he was a master. He could win rear end cases. He thrived trying auto cases, and particularly in Fayette County, but also surrounding counties. But there were plaintiffs' lawyers who were heavily invested in auto, and there were defense lawyers who were heavily invested in auto that you would hear talking at the family affair or in the courthouse about how they were afraid they were going to go out of business. That's how effective the threshold was initially. And a lot of the early cases are cases where the court's trying desperately to allow somebody to bring a claim, where they testified, I didn't get a rejection form. They said, well, you can bring a claim no matter how small it is. And so the courts were a little bit resistant about enforcing that part, while they were very lenient in enforcing the benefits portion. The reality is that with medical, and this refers to medical costs, but it's really a function of medical technology and the cost of that technology. But in my seminar, a lot of plaintiffs' attorneys come to the seminar. I don't really do it anymore, but I always like to tell them, I says, if you've got a case and you cannot find $1,000 of medical bills, then you should put your E&O carrier on notice, because one trip to the ER will do that. And they all laugh, and it's true. It really, there is no threshold at this point. So half of the deal is gone. Now, this is the setup on how medical expenses are handled has generated a number of problems with respect to how some medical providers handle these claims, and John's probably going to say a little bit more about this. And there's probably differences of opinion about some of it, but the reality is that it's set up so that you really can't challenge bills. It's the last bastion of what we refer to as retail, but I always think of it as Leonard Cox prices. I don't know if those of you are familiar with 1980s Lexington, but Leonard Cox was a clothier who would have biweekly bankruptcy litigation sales, and with 50-60% off, it was still 25-30% higher than any suit you could buy anywhere else. So what we call retail prices are really just prices nobody pays except for the PIP insurer, and that's at the heart of a lot of the problems. I think that it's important to realize, and I understand how that can be beneficial for providers, and I understand that the various federal statutes that have been enacted, along with the incredible bargaining power of large health insurers, hospitals, doctors, clinics, they're all starving for cash to cover the fact that they're not really being paid properly on these other programs. And that started out as a balloon, and the Medicare squeezed the balloon. Well, it popped out everywhere else. Well, then the healthcare providers came in and they squeezed the balloon a little bit. And now you just got this little bubble that's no fault. Even uninsured people don't pay the retail amount. They negotiate it down. Unless they just have a lot of money, they may pay it. And so there's a certain unfairness to why no fault is put in that position. But I want to point out that this really hurts the injured person, the beneficiary. And I'll tell you why. If you're entitled to $10,000 of medicals, it makes a difference whether one unit of treatment is $100 or $200. Because if it's $200, you're going to get half the treatment for your $10,000. And one of the purposes here is to try to get people treated if they were in an auto accident. So it actually works against the injured person and really doesn't benefit the plaintiff's bar, as far as I can tell. I'm not an expert on the plaintiff's bar, but so that's something that really needs to be either eliminated or addressed in some way. The court has really created a lot of the problems that we have, and I want to try to tell me if I'm running too long, but because I get to talk and I can't stop. As I mentioned before, the legislature set up a presumption of reasonableness. In Kentucky, the law is pretty well settled that a presumption gets you to the burden of proof. In other words, it shifts the burden of proof to the other side. But once the other side has some proof, the presumption disappears. And then the other side has to come in and rebut whatever rebutted the presumption. And if it worked like that, if it worked like the legislature intended, we probably wouldn't have a lot of the problems that we have. But the court has interpreted it in a way, while they call it a presumption, it's really an inference. They're saying the fact that they build this is proof that it's reasonable, which is rather circular. That causes it to be, when you combine that with cases that make it very difficult to challenge, or to investigate medical expenses, no matter how suspicious they are, it gives a free pass to the providers, and I want to emphasize some abuse that. And this is particularly true in Louisville, and I think at this point, I would point out that I think the way that medical bills are handled also probably increases premiums. But I'm not an insurance person; I'm a lawyer. So, but this has led to certain different kinds of fraud, and I'm going to defer at this point to John Bush, who kind of specializes in fraud cases for insurers, and to kind of elaborate on how these issues have been a problem, particularly in Louisville.
Thank you, Ron. As I mentioned, I've been a practicing attorney in the Commonwealth since 1978. While I have handled a few cases on the other side, on the personal injury side, the vast majority of my practice has been on the defense side. I am a member of the IIK, but I do not represent the IIK. I'm not an attorney for them, but they've been kind enough to ask me to come and hopefully offer a few things of interest today on the issue of PIP, and in particular as it has become Pip fraud in too many cases. As Ron mentioned, when PIP was first adopted in 1975, it was a great idea, and the intentions were really, really good. But unfortunately, because it is now the last bastion of where a medical provider can get paid basically 100 cents on the dollar of their bill, okay, it has created a huge economic incentive and it's a relative few, but it's an important few, and they generate a lot of fraud in terms of, or increased claims and things, and just in terms of the dollar amounts. It has created what I call the catalyst to bring together for the unscrupulous medical provider whose goal really is to use up that $10,000 as quickly as he, she, or it can, okay? Because if they were to bill that same $10,000 to Humana or to Anthem or to much less to Medicare or Medicaid, they would be getting at most 40 cents on the dollar of Medicare or Medicaid, even less than that. So it's important that you all understand what the economic incentive is for people to abuse this system. And part of that has become exacerbated by the fact that we've now had some decisions by the courts that have taken away the tools that the industry came up with to try to be able to investigate and to challenge these claims, short of actually having to have an IME, an independent medical exam, done. Okay, the statute provides for an independent medical exam to be done when you can show, quote, good cause. Good cause these days is done mostly by getting what's called a chart review or a paper review done. I think the statute uses the word peer review, but that's not really. Peer review is a term that means something else in the medical industry, really. But using a chart review to show that there's a need for an independent medical exam to be done. But short of that, there's no other way, really, for us, for the insurance industry to be able to investigate questionable claims at this point. We used to try to use the chart reviews as ways to shift that burden and things like that, and the court has taken that away. So when there's little opportunity realistically, without going to, and it's tremendous expense to have an IME done, when those other opportunities to investigate and defend against questionable claims have been taken away, you have that, plus you now have a system that's set up that there's no governance on it. The only governance in the PIP statute on medical charges is they are supposed to be, quote, reasonable, but nowhere in the statute is reasonable defined. And the net effect is, realistically today, a provider can bill almost anything that he, she, or it wants to bill, and it's going to be covered by PIP, okay? So what does that do to the consumer? What does that do to the citizens of this state? It allows, quite frankly, for the unscrupulous providers to grab onto those monies and all of those monies very quickly, and to charge for things that, or overcharge for things that if there was some other system that regulated the charges, it would be able to stretch out those $10,000 of benefits, like the legislature, I think you all intended, when I don't know if anybody here was in the legislature at that time, but when the General Assembly passed that statute in 75, that was the intent of it, was to have a sufficient amount of money to cover some medical expenses for somebody, reasonable amount, at least initially. And by the way, not only is there the $10,000 of basic reparations benefits, or BRBs, the statute also provides for you can buy additional layers of benefits, reparations benefits, that are called additional reparations benefits, or additional ARBs, or additional PIP. You can buy them in $10,000 increments for a total, I believe it's either a total of, I think you can add 4 more layers for a total of 50. I may be off, it might be 60, but you can ask your insurance agent, they'll be glad to sell you an additional layer of it, but up to $40,000 or $50,000 total. But most people, the vast majority of people, just have the ARB or the BRBs, or the basic PIP, that is provided when you get your policy. So what the system right now, though, is doing is it has enabled the unscrupulous medical providers to get together with personal injury attorneys, and again, I'm talking about a relative few in both professions, but to allow them to get together to use this system to game the system. Where did this first start? This really didn't start in Kentucky. So back when I first started getting heavily involved with PIP and PIP investigations, it was 1999 or 2000, and I had a major carrier in the state came to me and said, is there anything we can do about PIP? I'm being told by other attorneys it's like workers' comp, you just have to see the claim, pay the claim, whatever. And I said, no, I don't think that's right. But I said we need to set up, to do things properly and in a fair way, which is what we tried to do with the chart reviewing and things like that, and some of the other tools that have now been taken away. But what we saw happening at that time was a lot of the PIP fraud that is taking place in this state was imported, okay? It was exported primarily from Florida. We had a statute initially. If you were to go back to the beginning of our statute in 75, and I'm not sure when the Florida statute was passed, I think a little bit before
72.
ours, 72, our statutes were almost identical. If you were to look at them today, you would say, no, that's not the case, because they've tried to go through several major reforms in Florida. They didn't work there despite the best of intentions, and they all but did away with PIP this last time. If the governor hadn't decided for whatever reason to veto the bill, that Florida would no longer be a PIP state today. But so they've tried some major reforms down there. It hasn't worked because they've been addressing some of these same issues. But what happened down there is an industry developed of fraud by down there, and then some of the Florida people down there got the bright idea, well, Kentucky's a PIP state. They're like Florida used to be. Let's go up there. And so they exported some of that fraud here. It first started in eastern Kentucky with one medical provider who I will not name, but I know the name. I'll tell you later. I'm not going to mention it here in public. But who came to eastern Kentucky and started bringing in mobile diagnostics, okay? They were bringing in equipment with techs, not physicians, but techs providing, doing nerve conduction velocity studies and EMGs and ENGs, and then they began to come in with mobile MRI units and that type of thing, and they were charging exorbitant amounts, okay? And then next thing you know, here come the other unscrupulous medical providers from Florida started coming in. Then the law firms in Florida who were engaged, who were involved with those people, they started opening up offices, in particular in Louisville, and so they just became kind of an extension of their fraud departments, what you want to call it, their fraud units in Florida, came up here. And then we had some, non-Floridians, some of our, fellow citizens who decided, gee, this looks like a great way for the providers, the unscrupulous providers, to get paid a lot more than they could charge anybody else for the same services, even assuming that they were medically necessary, and many of the services we found were not. But that issue aside, to get together with and again, this is a handful of people in both professions, but to get together with willing plaintiffs' attorneys who they kind of scratch each other's backs using the insurance industry's monies and the patient/client's benefits. So what's the benefit then on the legal side of this, on the legal profession side? The benefit is the key to any personal injury case, the key to it almost always is your medical specials. Because you can talk about pain and suffering to a jury, and you can try to get and a jury excited about that or not. But that's kind of amorphous. We got medical bills here. These came from a physician. These came from some kind of a healthcare provider. Here, ladies and gentlemen of the jury, these are the hard facts right here. And then they use that as the jumping off point for the rest of the claim to try to increase a settlement or to try to increase a verdict. Well, if the proper amounts had been able to be charged, if the proper medical services have been able to be charged, and only those charged and only those performed, clearly the amount of the medicals that is used as the basis for a claim to try to settle it or try to get a jury verdict is less, and therefore the verdicts would almost assuredly be less. So what happens is not only are these benefits expended and expended, many of them improperly, and they use up, in the old days before the Affordable Care Act, what they did was they used the only medical benefits that a lot of people had available to them, okay? And they consumed them wrongly. And these people weren't really looking out for the citizens of this state and even for their clients or their patients. And again, I'm talking about a relatively few in both professions. But all they wanted to do is get that PIP money, fill in the $10,000 check with their name on it. And the attorney was willing to go, the unscrupulous attorney, whom they had gotten in cahoots with, or had gotten in cahoots with them, whichever way it worked, was willing to go along because it increased the medical specials that they could use then to try to negotiate a higher settlement than otherwise would have been owed, or to try to convince a jury to pay more on a claim than they otherwise would have been able to do. So those are some of the problems. And it's in Louisville, where I am, it is rampant. I think you all are going to hear from somebody from NICB maybe next month or the month after, I'm not sure which, a fellow named Tim Lynch, who is very familiar with all these problems, I mean, nationally, but especially in Kentucky. And I'm not sure if Louisville still holds the #1 spot for Pip Fraud in the country, but if not, I can guarantee you we're #2. And so we have a huge problem with this. We have had lots of cases where there have been, car accidents that have been staged, things like that, and then they jump on the PIP and they use the PIP to try to, ramp it up in the manner that I've talked about. So while the statute was intended to do good things, in effect, what it has provided, because there are no fee schedules, there's no objective way to address the billing cost at this point, it has unintentionally created the catalyst for the unscrupulous medical provider to get together with an attorney to try to use that to their advantage, but to the additional cost of the citizens of this Commonwealth. And this doesn't just result in additional PIP premiums being incurred, because when they use that money then to try to extract a higher settlement or a higher verdict, that comes out of the liability coverages, okay? So you're going to be paying more in liability coverages on your claims, then you're going to have to, as a carrier, you're going to have to figure that into your rates, which is going to increase the cost of the liability coverages as well as the PIP coverages. So those are some of the types of problems that I have seen in my practice that I know are out there. And while my practice at this point is focused more on Louisville than other parts of the state, I know that this occurs in other parts of the state as well. And so I just think it just needs to be addressed. And I appreciate you all giving me the opportunity to speak to you today.
If I could add one thing, the thing about the consuming the 10,000 PIP, there's another way that this, I think, injures claimants, but it's perfectly, legal, as far as best I can tell, is that if you have somebody who's entitled to PIP but don't have health insurance, the PIP becomes a draw to get them into that clinic or service. And then if they decide there's a more serious issue than 10,000 will cover, they enter into what's called a letter of protection. And this is a deal where it's a little bit like the loan services, but it's different in that you just basically sign a letter saying that they will get paid first for whatever medical services they're provided. And those will, of course, be at the, quote, retail rate. And this leads to these situations which, when they come to light, aggravate people, where between the attorney and the medical provider, they get 80 or so percent of the settlement. And none of this is illegal. It's, I guess, what you would call honest graft. But I think it's very harmful. Now, they would argue, and I have represented the firm that I believe was just discussed, so I've heard their explanations. They would argue that, well, but without this letter of protection, they can't get this treatment. And it is a little bit unfair to ask the attorneys to make judgments about whether they need a surgery. Although I think a lot of times attorneys at least feel like they know that it's really not necessary. But it creates an incentive. And I'm a big believer in incentives and disincentives. And the real problem, if you want to overarch it, is the no-fault statutes have evolved into a big set of bad incentives. And people are responding to those. There's dishonesty also, but some of it's just responding to the incentives that are in the act. And with that, since I wasn't supposed to say anything more, I'm just going to shut up.
Yeah, real quick, then we'll go to.
I'm sorry, just one more thing. If you don't believe that this happens, as you're driving into your community, I don't care how large it is or almost how small it is, take a look at the signs for the healthcare providers who are out there providing personal injury types of services. You will see on almost all of them, they're advertising auto injury. We want to treat auto injury patients, okay? And they want that business because the sign may say other things, but usually that auto injury thing, that signage will be a little larger than the others, so it's prominent. They want that business because this is the only place they can get paid 100 cents or close to 100 cents on the dollar. That's an incentive that shouldn't be there for the reasons I've discussed. And thank you for letting me add that.
Thanks. Your friends didn't leave you a lot of time, did they? Sorry.
2 minutes. 2-minute warning.
It's all right. Go ahead.
I won't need a tremendous amount of time. You see on the screen here, has Pip outlived its usefulness in Kentucky? And that's kind of an existential question, but it's a question worth having because literally every state has a culture of how they do auto accidents. Every state in the United States has a unique way that they deal with the misfortune of someone having an auto accident, particularly if you're injured. Kentucky is very unique in how we deal with that through our Motor Vehicle Reparations Act. And it's telling that, as you saw in previous slides, that no state has adopted a no-fault scheme for over 30 years. Several states have repealed the no-fault law or schemes that they have in their states. But several states still have it, and it's woven into kind of the culture of our state and these other states of how they do auto accidents. And as far as its usefulness is concerned, it kind of depends on where you're sitting. If you're the injured person in an auto accident wondering, how do I get treatment? What do I do? Chances are you have health insurance. But if you don't, you're awfully glad that you have this PIP coverage. Or if you're the injured party, or the injured person, and you have all these bills and you need to keep a little income coming in, the law allows you to keep an income stream coming in. You can reserve your benefits for things that you need it for. So in that aspect, PIP can be a very useful coverage. If you're a provider, some providers don't get paid very much from health insurance. If you're a chiropractor, for example, or a physical therapist, you may be very limited in what you can collect from a person's health insurance company. PIP, on the other hand, as you've heard, it will pay. It will pay promptly, and it will pay basically whatever it's billed. That's part of the problem, because that can be easily taken advantage of, as you can probably imagine. That's not what I think the legislature intended it to turn into. The statute actually has a provision in it that says the insurance carrier, the PIP provider, owes for reasonable and necessary treatment. And that sounds fair. I don't think there could be a big argument about that. The burden of proof is basically on the PIP provider to show that what it's paying is reasonable. That can deal with that as well. It's turned into something quite different now, though, where basically anything that's billed, as Ron was talking about, you have to pay it. Your only recourse, if that bill is outrageous, is to try to negotiate with the provider. Well, they don't have any real incentive in many cases to want to negotiate. If I can bill whatever, there's no fee schedule, you have to pay this. It says this in this case law. And that's where the courts have kind of taken the law and changed it from one animal to another over the course of the years. But, you know, your recourse is basically to file a lawsuit against the provider. Nobody wants to really do that. That's not an effective way to manage that situation. So, you know, from that particular standpoint, maybe the coverage is not so useful. So again, it kind of depends on what side of the situation you're in. It can be useful at times. It can be problematic. On a grander scheme, you know, people move to Kentucky and they're like, why are my insurance rates so high? We're surrounded, as you saw on the map a little while ago, by states that don't have this coverage. So insurance tends to be a little more expensive here. Is that a good or a bad thing? Well, the citizens of Kentucky have to decide that. The legislature has to decide that. Again, this is part of the culture of how we do insurance and how we do auto accidents in Kentucky. But the coverage is difficult to sort of manage. There's really no tools to manage it. And now with some of the recent case law, you know, you get a bill, you're charged with paying it, you better pay it promptly, or you're going to be paying 12 or 18% interest. Who wouldn't like those rates today? And so on one hand, that's good. That holds the industry's feet to the fire to get things done quickly, and that's not a bad thing. You know, that's my profession. You know, we want to do things the right way. We want to take care of our customers. But at some point, you know, the line of fairness has kind of gotten very far afield. And it's very challenging now to handle these claims within a person's limited coverage benefit. They go to the hospital and they come out with a bill, they had an x-ray, they have no idea they walked out with a $15,000 hospital bill. That's a problem. The coverage doesn't even come close to taking care of that. So, you know, from that aspect, PIP is not as efficient as it could be. So, you know, for people that have auto accidents, they don't even know they have this coverage a lot of times. They're sometimes very pleasantly surprised to find that they have a coverage that will help pay their medical bills. And so, you know, we help walk them through the process. But they're also disturbed to find that when their bills start coming in, the coverage didn't go very far. So, you know, again, the idea of PIP started out, that's why so many states rushed to adopt it. You know, it sounded like a great idea. There's elements of it that are still beneficial to the consumer. You know, that if you have the accident and you need that coverage, at that time it can be very beneficial. Chances are today, though, you have other insurance that would take care of that. So you have to ask the big question, is this a coverage still worth keeping? You know, other coverages are offered by insurance carriers, MedPay, for example. You can buy a coverage that would help supplement your coverage, your health insurance if you want it, to help pay the deductible or co-pays and that sort of thing. So that's available in Kentucky as well. Most insurance carriers sell that coverage as well as PIP, which is a mandatory coverage. And our culture in Kentucky is, we want you to have this coverage, consumer. It's mandatory. If you don't want it, you have to fill out some forms and send it to the Department of Insurance and tell the state, basically, I don't want this coverage. Most people don't do that. Most people don't even feel comfortable dealing with that whole concept. So we're here, just want to have the conversation, maybe get some thoughts and ideas on either, is this coverage worth keeping? And if it is, what can we do to make it reasonable for everyone? You know, the consumer, the provider, and the insurance carrier alike.
Thank you. We're going to have a few questions. I'm sure there'll be some time for some more discussion here. I know we have another meeting next month to keep on going on this, but Senator Alvarado was the first one that had a few questions. So, Senator.
Thank you, Mr. Chairman, and thank you all for this topic. So I'm pretty familiar with this, obviously, and a lot of the issues. I think I know the group that you're probably going to be, you didn't mention them by name, but I think I know who you're talking about. It's kind of a well-known group that, having done primary care work, I know it was easy for a lot of primary care doctors. They tend to go to PCPs, person comes in with an accident, they have complaints, there's all kinds of paperwork, which we're already up to here as primary care doctors. These guys say, hey, we'll manage it all for you. You refer the patients there, and they manage it all. Patients are happy, it's managed well, they get better, everything gets improved. But when I find out later, there's a lot of other issues that come on the back side of this. This to me sounds like surprise billing, just on the other side now. It's for insurance companies instead of the providers or patients that complain about it. And it's the same thing. It's an out-of-network provider that's going to basically say, this is what we get. The way the law defines it, they can do that. So a couple of questions that I've got. One is, we've just had a federal law passed, we know, on surprise billing when it comes to medical insurance and that sort of thing, and kind of holding the patient harmless, and there's a negotiated agreement between both parties, and they can use some databases to determine what a fair cost would be. Have we thought about using that same kind of a model to solve this problem in Kentucky? And the second one would be, we thought about using like an all-payers, I don't think we've developed one. There's been some discussion about getting an all-payers database set up so we can find out exactly, it helps us track a lot of disease states, but it also helps you track costs as far as what an average cost would be that might help bring this into range. If we thought about using those two types of things to bring these costs down, to make it where it's a fair reimbursement, but also no one's getting gouged.
Senator, just to clarify, your first question is about some kind of fee schedule or something of that sort, or can you clarify?
An out-of-network billing, what we had proposed in this state before for several years, we couldn't get through, but eventually almost the same models would pass on the federal side, is that if you have a patient goes to an out-of-network provider, there's no contract between the insurance company and that provider. So how do you determine what they pay? They say, hey, we charge $1,000, we want $1,000, we want retail, right? We don't want to have a discounted price, which still, as a provider, bothers me that we can charge it, and the norm is to get paid less than what you think your services are worth. That's a discussion for another day. They say, we want to charge this amount. We don't have a negotiated contract. The insurance company says, hey, that's too high of a cost, and we're not contracted with you. Pass it on to the patient. The patient gets stuck with a $1,000 bill that says, hey, I don't know what I'm doing here. I have to pay this amount, and they get stuck. People went bankrupt with a lot of these things. So what we did is we said, hey, we're going to take a look at what an average cost would be effectively, and you kind of have an idea, and you force the insurance company and the provider to come to the table and negotiate a rate. And if they can't come to a conclusion, there's a base kind of rate based on what is being paid for that service already. So there's lots of different models that are out there, but it would effectively be something along those lines, where it's kind of a surprise billing bill for this model to come in and say, we're going to require providers, providers that are providing the service, to say you're not going to be able to gouge somebody and just charge retail. You're going to have to come in with something that's a bit more reasonable, and that can be required to be a negotiated amount, or go to an arbiter if it gets to that point where no one can agree, to force it into that kind of a system. So something along those lines. And then also, again, just collecting the data, because a lot of times, and this is the argument we have for a lot of healthcare transparency, I tell people, what does an MRI of your knee cost? Well, it depends on who's paying. If you get in a car wreck and it's through State Farm, it'll be $3,000 because that's what they can charge for the retail amount. If it's through Aetna, because you have arthritis or meniscal tear, it's $1,200. If you're self-pay and you're paying out of pocket, well, we'll do it for $500. So what's the cost of the test? It just depends on who's paying the bill. That's part of the problem we have. This is the high-end one. So what I'm thinking is, can we not use model language we have for surprise billing, we use for medical kind of insurance, and negotiate those issues to protect patients, to do the same thing here, to make sure that a payer isn't getting gouged, and that you can find some kind of a middle ground there to provide what it's really worth.
Yeah, and we have, I'll probably defer to Owen on this, since he does this every day, all day, but we have offered legislation in the past that would have used the workers' comp fee schedule that was deemed not to be the best approach by a number of providers. I think especially hospitals had issues with that. Essentially, all of PIP is pretty much non-network. But Owen, do you want to address some of that?
Thanks, Mark. And Senator Alvarado, those are excellent points. And the database, that idea, actually there are more than one that exists. One is a not-for-profit database. It's called Fair Health. It's nationwide. It's very robust as far as the information in it. And insurance carriers were actually, it's available to anybody, consumers, insurers, and they're pretty granular in that you can get down into geographic areas and kind of see the differences in what the healthcare costs are. Personally, I love a system like that. It's the fee schedule is kind of a locked-in price. You have to kind of adjust it probably year to year or every other but something like that would be have some flexibility to it, make some sense. Certainly we understand providers need to be able to charge a fair amount. They get squeezed every which way. It's tough on them. We realize that it's tough on the industry too to get bills that are just crazy and what's your recourse? The problem that's happening in Kentucky is that a statute in particular that we all kind of interpret it as, hey, as long as we can prove our data that what we're paying is reasonable, we're willing to put our neck on the line and say, hey, this $500 office visit should be $250. We feel like we have good data to show that vast majority of providers charge that. But a court case from 3 years ago basically said, can't do that. If you get the bill, then you have to pay it. And if you don't like what was charged, then your recourse is to either call them up, try to negotiate with them, or you can sue them. Well, we don't want to get into that. We can avoid that.
For the cost of cases, it's often not worth, if I may, Mr. Chairman, not worth the cost of going to court. But again, this is the same discussion we've had and again, this is a bill I proposed. I would encourage you all maybe to talk to some of your other partners in the insurance world and the medical side, because I got a lot of resistance on this concept that you're saying might be reasonable. Got a lot of resistance from the healthcare insurers saying we don't want that. And I think it would have been a good middle ground. So, and I'm probably looking at filing a bill to create an all payers database so we can have something to base this off of to help do some of these things. So that's why I was wondering, Fair Health is another group that you're right. We were referencing that organization in one of our bills to try to say, hey, we're going to be able to let them collect the data. They're nonpartisan, they're not political, they're just there to present information, and then we could use them for that. And the last thing I'll mention, Mr. Chairman, also, I know you mentioned the words defensive medicine, which obviously for me, I think whether for better or worse, I'm well known as a guy who's for tort reform in this state that we desperately, desperately need. I think we're number 2 in lawsuits per capita in the country, and people don't realize how bad of a situation there is. Talk to our bar association, who doesn't perceive a problem, but there's significantly one there. And when you talk about providers having to use imaging as defensive medicine, I can tell you that's become the norm. It's not where you use your judgment. No one trusts provider judgment to say, I don't think you need this. Well, you might be wrong. I want an x-ray. I want a test. That is never wrong, they think, although it can be. But they want that because that's what we're going to use, and our attorneys push that as well. That is the crux of a lot of these things also, is people saying, I'm going to do this. It's a cheaper insurance for me than having to pay higher malpractice insurance premiums for a lot of our providers. And so that's a problem that needs to be fixed in our state as well. And I'll be filing that also every year. So again, it's something that's continually needed. But I was just curious about the database and maybe looking what the feds have done when it comes to surprise billing, using a similar model for this problem would be, I think, a good idea.
May I address this as well in just a moment? There is nothing in our PIP Act right now, our No Fault Act, that mandates negotiation. There's a provision in there that allows a carrier to ask a provider to negotiate, but there's nothing on the other side that requires that the provider negotiate. And as Owen said, there's no incentive at this point for the provider to negotiate, especially with some of the case law that's come down recently. And so that there's just nothing there to force that type of discussion, negotiation type of discussion that you're talking about. I personally, just speaking for John Bush, as an attorney of a few years of experience in this Commonwealth and engaging in these areas of law practice, I would welcome that type of thing as if, to be implemented. I think the question, though, is everybody, I suspect the question is, or part of the problem is, everybody's going to have a different price point. In other words, a different schedule of those that are already out there that they would want to use. Obviously those who are doing the paying would probably prefer something on the lower end. And that also stretches out the benefits for the consumer, okay, for the citizens. But those on the other end, the provider end, and those who have an interest in running up the costs that I've mentioned, they want things to be, that money to be consumed as quickly as possible and for them to be paid 100 cents on the dollar as quickly as possible. So, we've got this whole spectrum of different types of schedules or other databases, to use. I think we just need to pick one that will be probably equally unfair to everyone. I've always said as an attorney who did a lot of trial work, especially earlier on in my practice, if a settlement happened and both sides were unhappy, it probably was overall a fair settlement if both sides were. So, maybe it's not a matter of even trying to find the one that's, quote, most fair, because every interested party is going to have a different definition of that. But if you can find the one that is least unfair to everybody, in other words, it provides fairness to everybody, but maybe not the full measure that each side thinks they're entitled to, maybe that's the way to go. There are these databases out there in addition to the one that you mentioned, and they've been available since 2000. And we in part of that plan that I was telling you about that I tried to put together for this carrier who first came to me with these issues, we used an outside medical reviewing company to help get these medical these chart reviews done, but it also had a component to it that said, okay, based on these chart reviews, here is specifically what does appear to be owed, and in terms of dollars and cents that was allocated out by line items on the bills, and here's what's not, and here's why not. There's a coding system that said, this is why we don't believe this should be owed or shouldn't. It's just excessive in the amount being charged, whatever it was. So I think some type of schedule on these things so that we get away from this totally amorphous phrase in the act that says, you can charge reasonable charges would be extremely helpful. And I'm not familiar with the Surprise Billing Act that you mentioned, the federal act, but I will go take a look at that now that I'm aware of it, because a lot of this would I think probably fall in that category.
Thanks, Senator.
If I could make one observation.
Now, we've got multiple questions here from several guys. Do you care if I go ahead and work my way through them so we don't run over time? I don't mean to cut you off, but there'll be some opportunity for you to fill in if you don't care. Representative Gooch.
Thank you, Mr. Chairman. Something that hasn't even been mentioned here today that I think is a very important part of PIP is loss of wages. That's actually included in that, and possibly someone's in an auto accident and their eyeglasses are broken or something. I think that is covered as well.
Well, the loss. I'm sorry. Go ahead, Owen.
No, you're correct.
Yeah, right. The Act currently provides for up to $200 a week of lost wages under basic PIP coverages. If you have additional coverages, I think that goes up to $300 a week. Again, that was set back in basically 1975 as well. So,
and I will add that claimants also have the right to direct among the different elements. So if someone says, I want to save all my $10,000 for lost wages, a claimant has the ability to do that in lieu of having medical bills paid. They just need to inform their insurance carrier.
Okay, Mr. Chairman, if I might, when I came here in '95, I had an independent property and casualty insurance agency, and I very much liked the idea of PIP, where if someone had an accident, auto accident, before, they might have to, if they didn't have medical payments, they might have to wait a long time to get their loss of wages covered and their medical bills and all of that, and then finally sue the other party. And this was a way that people could get, maybe their medical bills covered and their loss of wages. But one of the things that's happened is, as you said, this hasn't really worked that well because most people only carry $10,000, and that's used up really, really quick. And that really hurts the consumer, I think. I encourage everyone to have increased PIP. I do, because you get not only more medical coverage, but you also get additional lost wages and those sort of things. But I probably have been working on trying to change this. Mark, you agree? Then probably had more bills to do this than anyone else. I very first started to try to change. I don't see how anyone could have, and I should have been malpractice to write into legislation a phrase that any bill presented was presumed reasonable. I mean, whoever the bill drafter was that wrote that and the people that voted for that, I mean, that was, and so we tried to change that. We couldn't do that. We tried to, as Mark said, we tried to pass a bill that would include the workers' comp fee schedule. We've had other bills that tried to prevent some fraud from people working together in specifically Louisville and other places. But I think that there really is a problem when a plumber on his way to a job and a mom taking her kid to school, they collide. Both of them have a broken leg. The same ambulance provider comes out to pick them up, and they can charge the mom a lot more. We've seen as much as 3 to 5 times as much to go to the same hospital as they charge the guy's plumber who's under the workers' comp fee schedule, as well as once they get to hospital, it's the same thing. And that is just not a just system. We've been trying to change that for many, many years. I do think that if having the current law the way it is, we might even need to look at possibly changing or eliminating the PIP law. But I think if we do that, I would want us to mandate some type of medical payments coverage and maybe even some type of lost wages in the auto insurance policy, because I don't think that it's good enough to say, well, you could buy that through Aflac or something else. And the system has worked, but the numbers don't add up anymore. But I still like that the consumer, once they have those medical bills or those lost wages through no fault of their own, should have a place that they can be reimbursed for those. Thank you, Mr. Chairman.
Appreciate it. Representative Smith, I think, had a question or comment.
This is probably just for information because I sent a question to ask you from our school district is on the PIP. Is there a reason why students on buses have a 20,000 cap where individuals, just private individuals, has a 10? Does any, Mark, is there any reason for that you know of, or why school districts have a 20,000 PIP charge on students in buses?
I'm not aware of that.
Yeah. Okay.
I wonder if it just hasn't been purchased as 10 basic and 10 added.
Okay. All right.
I don't think it's mandated by the statute.
Okay.
Yeah, I'm also not aware of that being the case, but
that it being a regulation, you just think it's a volunteer thing for the districts themselves.
It'd be a guess, but yes.
Okay.
Representative, that rings a bell, but it rings it very faintly, far off in the distance.
Do you care to get that information for me so I can answer it for
I
him?
can check on that. I
appreciate
think perhaps it may be a regulation for school districts, but I am not.
That's
certain
what they're.
at this
That's
point.
what it was brought to me as, and that's since we was discussing PIP, they just want me to ask that. Thank you, Mr. Chairman.
Thank you, Representative Flannery.
Has the 10,000 coverage amount ever increased, or has it been that amount since the enactment in 1975?
Was that in 1975?
yeah, it's never changed.
Follow-up question. It appears in the 70s from the slideshow that there was kind of a movement for PIP and what we call basic reparation benefits. In the 70s, was 10,000 the norm for most of those states, or was Kentucky unique in that?
Do you know? I don't know.
$10,000 is what Florida started out with, and a few other states as well. But some states have much higher limits.
Michigan was unlimited, and I don't know if that goes all the way back to the 70s, but that's been a big problem there, and I think recently
They've recently
changed it.
changed that.
They did put some limits on it, yes.
But are those coverage minimum amounts, have they evolved over time in these other states, or is Kentucky kind of an island to itself where it's been static?
Kentucky's been relatively static in the fact that you can buy additional PIP is available. I think this would be trying to get into the minds of the legislature at that time in 1974 and 75. They probably wanted to keep the cost reasonable, $10,000, versus say $50,000, which a few states had that as their basic limit. That's going to be more expensive. So probably the legislators were keeping that in mind for the consumer in Kentucky at that time, and give the option to buy additional PIP. But some states have reined back their, like Michigan and New Jersey, a few years back, went through a legislative process to give consumers choices where they didn't have to buy as much coverage because it was so expensive.
And keep in mind that in 1975, $10,000 probably fully treated some high percentage, 80, 85% of the injuries. And so it was probably a very generous number in 1975.
And Representative Flanner, if I might add, I haven't been part of these discussions, but I understand some of the discussions that have occurred over the years about on that issue have been that, for example, some of the providers out there want to have it raised, and there may have been some resistance from some of the property and casualty carriers, because if we've got $10,000, it's that issue right now, and if we don't have any checks really on it, we got all the problems we've got right now. What's the incentive for the industry to agree to raise it to 20 or 30 or 40 or 50 when all we're doing is adding, we're doubling, tripling, quadrupling, quintupling a financial problem for us because we don't have the tools right now to manage this, regardless of whether it's $10 or $10,000 or $50,000. So if an increase in the basic amount is on everybody's minds, and if that should occur, please, if we're going to keep it, give us the tools to manage it and to prevent the unscrupulous from being unscrupulous, and for us all to act fairly throughout the process.
In short, if we don't do something about fraud, all we're doing to do by raising the minimum is get twice the amount of fraud. And I will add that, as we mentioned, a person does have the ability to optionally purchase higher coverage. What we're talking about is potentially raising the minimum. Of course, that has fraud implications, but also anytime you raise the minimum coverage for any issue, there's a trade-off in that. And because higher coverage, higher minimum coverage means higher premium because of higher costs. Higher premiums means some people, more people are going to make the choice between being uninsured and insured. It will increase the number of uninsured when you raise the minimum premium, or raise the minimum coverage and therefore the premium.
Representative Flannery, did you have another question? Okay, good. Well, the thing about it is, in 1975, when this was created, this probably sounded like a really good idea, and there probably wasn't as many people trying to abuse the system.
Yes, sir.
And you had folks that said, "Hey, this is something good. It entices people to want to live in Kentucky. It's great for the customer. It's great for the coverage folks. It's it's a good system." And then you have all these people that are coming by and realizing, "Hey, man, there's an opportunity here for us to really make a lot of quick money," and money attracts a lot of people, and that's what's brought this to be the point of where we're at now. I feel like I'm an old man at 44, and I was born in 77, so this has been around for a day or so. Yes. And so it's starting to create some issues that we need to be addressed. I've been here almost 12 years now, and I think it's one of the things we discussed 12 years ago. So there's lots of issues up here. It's something that really we have friends on both sides that bring valid arguments to the table, and you're trying to discuss what's the right things to do. And, like Senator Alvarado said, he's had these discussions, and you start getting people that you would think would be on board of what you're wanting to do have major pushback against the same bill that you're trying to present. And so there's so much misinformation. Hard to believe up here in Frankfurt there's misinformation, but there is lots of that. So we have lots of discussions, and that's why we're working to deal with this issue. And we've got good folks involved of it on both sides, and hopefully in the short term we can get something done to make sure we can protect our consumers and still not drive rates up to where they're outrageous, and still provide a quality thing to where people can't abuse the system. And we're in a world now that everybody is looking for the easy dollar and trying to abuse as much as they can. So we want to make it affordable and still attractive. So was there any other questions or comments from any other members? We ran just a few minutes over, but when you get 4 attorneys and 2 or 3 insurance guys involved, you can't expect them to stop, right? Yes. But no, we appreciate the insight. It's a major issue. It's hard to have the discussion in 1 hour. That's why we're doing this over a several day time frame here, several meetings. Representative Rowland will be chairing it next month, and we'll have more in-depth discussion. So we appreciate that, guys. With that being said, do I have a motion for adjournment?